Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is the time set for oral argument in Compassionate Care Dispensary versus Arizona Department of Health Services. Our case number CR2 Each side is allocated 20 minutes for oral argument this morning. Appellant, you may reserve, if you choose to, a portion of that time, but if you for rebuttal. But if you choose to do that, you'll need to keep track of your own time at the clock at the podium. Out of respect for counsel, I would ask those in attendance to make sure that your cell phones are either off, preferably, or in vibrate, so that our presentation today is not interrupted. We have reviewed the briefs. We've conferenced the case. We encourage you to keep that in mind as you present argument today. Our proceedings are being recorded and will in due course be posted on YouTube. So please, as you begin your argument, state your name and who you represent. With that, let's start with Ms. Ward.
Thank you, Your Honor. We would like to reserve 10 minutes for rebuttal. We're here today because we feel that the trial court erred when it found that the lottery process was akin to the awarding of a public works contract. And in finding such, it found that it thought that Compassionate Care was seeking an interest in the certificate, and thus found that it had no protected interest. That was not the case. The DHS was given the duty to execute the Arizona Medical Marijuana Act and to award certificates. And it decided to do so by lottery. And the purchase of a lottery ticket, the price of a lottery ticket, was first $5,000. Second, they had to put up $150,000 in capital. Third, they had to secure a location, and if that meant paying money on deposit, or in this particular case, Compassionate Care had to buy an option to purchase the building. The landlord wouldn't let them operate unless they agreed to purchase it. And fourthly, they had to comply. They had to present to the DHS a certificate of compliance with local jurisdiction zoning. So those were the four elements that all those that wanted a lottery ticket had to comply with. So what Compassionate Care, and even the court even found that Compassionate Care has spent tons of money. If you look at the transcript on page 7, they specifically say that surely they had a right, a substantial right in the fair and impartial carrying out of that lottery. And the DHS agreed with that. And we don't disagree. That's what we're saying here. That's what we're doing here. Is that the Compassionate Care complied with all of those things, and all Compassionate Care has ever asked for is equitable treatment of all those that bought the ticket. That the same requirements apply to each and every one that purchased the ticket.
Assume that we agreed with your argument that it didn't move along fairly. What specific relief are you asking for from this court?
At this point, Your Honor, we're looking for special action relief in which we can seek damages. We're not seeking equitable relief. We don't claim that TMR, the applicant whose ball was drawn, did anything wrong. We don't say that the city of Winslow did anything wrong. We've never claimed that they did.
Counsel, what's the substantive claim that would merit damages?
The substantive claim that was exactly what the trial court recognized, that in reliance on the DHS.
Specifically, turn it to a special action. Let me back up. Two claims: special action / mandamus and declaratory judgment relief. Those are the two claims in the complaint. In the prayer for relief, you asked for damages. Which of the two theories, special action or declaratory judgment, justifies awarding damages under Arizona law?
I think the declaratory judgment would be able to do that. We would be able to make that claim.
Do you have any authority for that?
We're just looking at the special action, and when I looked at the special action, Your Honor, in order to, for special action to apply, we had to have a substantive due process right, and we contend that we did when we spent all of this money in reliance on the DHS mandating these requirements. The DHS specifically said they weren't going to evaluate the quality of any ticket purchaser. They weren't going to look at the substance. They were only going to require that they pay all this money. And in this particular case, Compassionate Care cashed out retirement funds to meet that $150,000.
Aren't you suggesting then, isn't your argument boiled down, is that under Rules of Special Action 3, that the department acted arbitrarily and capriciously in the process, if you will, in failing to exclude one of the applicants? Isn't that the essence of your argument?
The essence of the argument, Your Honor, for clarity's sake, is that the DHS had an obligation to carry out a fair and impartial lottery, and that
Correct.
Compassionate Care would not have purchased that ticket except in reliance on the DHS promise that it would be done in a fair and equitable manner, and that each ticket purchaser would be required to meet the same requirements.
I understand.
And that didn't happen.
How do you get damages? Well, I'll just ask you this. Does the record reflect that
Reliance
you've made any
damages.
notice of claim has been filed in this case?
We never got to that. We did have we did file a motion to amend, but the court, granted the motion to dismiss before we could amend our complaint. We still have a right to amend.
To ask an obvious question, wouldn't the time for notice of claim have run a long time ago?
Not in this case, not since we've preserved it by filing suit. The DHS specifically set up the rules so there would be no oversight.
Counsel, let me ask you, isn't the notice of claim a prerequisite to filing a notice, or to filing a suit for damages?
Well, a notice of claim with the jurisdiction, with the locality, administration?
The public entity that you're claiming owes you damages.
They gave us no recourse to do that. They shut us down. They wouldn't let them talk to us. We couldn't file a notice of claim.
Well, and we're getting far afield from the briefs on appeal, I think, and far afield from the briefs in the Superior Court. And remembering that the Superior Court was the first legal challenge that you and your clients filed. But you say that the relief that you seek now is money damages, correct? And against the state agency?
Yes.
Okay. For what they did that brings us all here. Is that fair?
For failing to carry out the fair and impartial lottery.
Well, I understand
Okay.
your adversary probably views it somewhat differently than that. But that action happened kind of a while ago. And I understand that there may be a procedural vacuum in terms of regulations to challenge that administratively, and we'll hear from both of you on that. But if your sole remedy that you're seeking now is money damages, a notice of claim hasn't been filed. I think the timeline for those is 180 days, and there doesn't have to be a procedural mechanism for a notice of claim, and that's why I'm struggling with with the thought that what you're seeking here is money damages.
Well, when the
Are you seeking any other relief besides money damages? Are you saying that the rest of the questions are moot?
we're saying that we would not ask at this point for the DHS to reverse its decision because it would harm other parties that are innocent. And so we're seeking to be made whole for our reliance on the promises made by the DHS. And that as far as filing a notice of claim, we tried to go through the administrative remedies and found there were none. As a matter of fact, the DHS told the court.
I think what Judge Thumb is, well, we are getting far afield. And I think one of the reasons we're getting far afield here is there was no discussion in your opening brief whatsoever about damages, was there?
Yeah, yes, there was. We did discuss being harmed, and that's the reason. I'm sorry.
Enlighten me. What did you discuss about damages?
That's what we told. That's the reason on the transcript you'll see where the judge said.
On appeal, what did you say regarding damages that the Superior Court aired regarding its ruling?
It found that it had no substantive right. We couldn't even proceed We can't even proceed based on the trial court's order that the DHS there's no special action, no right to writ of mandamus, no right to any remedy. There's no judicial remedy.
Help us on your claim for damages, though, before that hearing, because I don't, and you're closer to the filings that were made in Superior Court than I am, but I don't remember that due process was a sort of front and center feature pre-hearing of the briefing.
Due process was there. They admitted that the due process claim was there. They said it was on page 12, but it was still there.
In terms of a protected property interest, sort of
Yes.
substantive due process or procedural due process?
We argued that they were entitled to both because they relied on the DHS carrying out or applying the rules for the lottery to everyone equally.
And let me ask, just to clarify a bit more, of the two claims that Judge Brown referenced, your position is that the special action would afford you a claim for monetary damages?
And we would be able to amend our complaint. We never got to amend the complaint.
That's not something this court's been asked to do, nor is it something that the Superior Court's been asked to do. So as far as whether a pleading would be amended or not, that's something sort of down the road. But you're claiming that you would be entitled to seek money damages for the
Yes,
special action claim,
Yes.
and then money damages for the declaratory judgment claim?
Yes, Your Honor.
Okay.
As far as the amended motion for leave to amend, we did ask the court for for leave to amend. And the court granted the motion to dismiss before we had an opportunity to amend.
And what did that amendment seek? Did that seek to add monetary damages?
Yes. A claim for monetary damages, a claim for restoration to the party back in the position it would have been had not been for the actions taken by the DHS, the arbitrary, and we contend arbitrary and capricious, especially in light of calling the city of Winslow and
Did I
using
hear
its
you right,
influence.
though, that you've given up on that second claim? That's not what you're seeking now.
We're not seeking them to reverse the award of the certificate to the one that got it, because the damages, it's hard to unwind.
But I understand, and I understand your predicament here. But if we were to disagree with you on that you're entitled to damages with regard to a special action and or either declaratory judgment without an if our court were to disagree with you, is the case over? From our perspective?
No.
Why not? Why not?
No, because we're asking for a right to be heard because we were denied our due process and our substantive due process rights. We got neither of those.
But to follow up from Judge Thomas' question, it sounds like you're not conceding that you do want. Can you have it both ways? Aren't you seeking a judge to tell you that what the department did was arbitrary and capricious? Are you not seeking that determination, regardless of whether there's actually a voiding of the award to another certificate holder? Are you not seeking a determination that what the department did was that they interfered with the process, or they unduly unreasonably exercised their discretion in a way that was to the detriment of your client? Is that what you're seeking?
And we're not, that's correct, but we're not willing to concede that we don't look for any other damages. We're not saying it's absolute. We're just saying that if the court determines that that has gone too far, then we would want, in the alternative, to seek compensatory damages. That's what we want. We want this court to find that the trial court erred when it found that we had no substantive or due process rights, because it found that those rights were not contained in a right to operate a medical marijuana dispensary. Compassionate Care never contended that it had a right to operate a medical marijuana dispensary. It contends, and the DHS agreed in the transcript when the court says they spent tons of money. Don't you agree they have a substantial right here? The DHS said yes. So, but then the court went on to find that we had no due process rights, and that the special action statute didn't award any, so therefore you're out in the cold because you don't have a due process right in the certificate. We've never asked for that. We've contended that we have a due process right, that they relied on the DHS carrying out the lottery in an impartial and just manner. They were in putting up $5,000. They charged $5,000 for the ticket. They charged $150,000 in capital for the ticket. They mandated they had to have a building. If that cost, there's a lot of damages here that the DHS specifically set up in the rules that they had no oversight. They had no oversight. They specifically said it that way. So there'd be no administrative remedy. So there'd be no judicial remedy. So when you're saying we didn't give a notice of claim, they have put it in the rules that we can't. We can't have any remedy. And that's exactly what the DHS did.
Under ARS 12820, 01 or 820, the citation, any claim for damages against any government entity in the state of Arizona must be initiated by filing a notice of claim. Now, are there defenses to lack of compliance with that? Perhaps. Or waiver, defense. We're not, those issues aren't before us. But just to clarify, I mean, I don't, in my opinion, it has nothing to do with administrative remedies that are available. It is a statute that applies to all government entities in the state of Arizona if one is seeking damages from that entity.
And we would be seeking that this be unwound, that this be, that if we have no right to, if the court found that we had no right to any compensatory damages whatsoever, and you're out the water for the $250,000 that you've spent, then yes, we would ask the DHS to unwind it then and treat all the applicants fairly.
Thank you, counsel. Appreciate it. Mr. Falls.
Good morning, honorable judges. I am Gregory Falls with Sherman and Howard. We are appearing here today on behalf of the Arizona Department of Health Services and Will Humble, its director. I must admit I'm a little taken aback at the turn that this appeal has taken here at argument today. It was our understanding coming into this that we were dealing with a order dismissing a complaint that had 3 causes of action: declaratory relief, an injunction, which is moot now, and mandamus, which is an order telling a public official to do his job. There was a claim for damages in the complaint, but again, this was an order dismissing the complaint, so we didn't even get to the defense of, sorry, you failed to serve a notice of claim. I don't believe that this appeal is about whether the appellant can assert damages, and if so, in what amount. This appeal is, as stated in the briefs, about whether there is a right or not on the part of the appellant to assert that right, that substantive right, in a court of law. Now, some of the arguments that were made in the briefs were that the Arizona Medical Marijuana Act really gives no discretion to the Department of Health Services, that the department is just stuck with rigidly doing its job. That's not true.
Wait. Why isn't that true?
Because
don't they just have to check a box? I mean, or a box comes, an application comes in, box is either checked or not checked, and then they verify, is it complete and compliant, correct?
Yeah, I mean, that's a good question, but no, that's not true. And the reason is, first, the Act itself is just a basic outline of the law and directs the department to adopt rules and regulations to enforce the law. The department adopted regulations that are, to a certain extent, fairly extensive, and among other things, there is a requirement that the applicant have $150,000. They didn't have to pay it, they just had to have it. But beyond that, and let me give you an example. There are some places where AMA is very specific. You cannot have a dispensary within 500 feet of a school. That's real easy. Yes or no, check the box. Correct. One that applies here, though, there are places where it's very general, and that is, for example, zoning restrictions must be reasonable. And what do the regulations say? The regulations say, well, first the statute says we want a sworn statement of zoning compliance. And that's really all the statute says. The department took that a step further. And
That's not exercising much discretion.
Not at all.
Not at all. Okay. So the department goes to the next step and begins exercising discretion.
Well,
I'm going to cut right to the heart of the argument, because I think the road you're going down here, yes, the department exercised discretion here, but by doing so, didn't they put themselves directly under the umbrella of mandamus? i.e., a government employee agency cannot act arbitrarily or capriciously, and if they do, then they're liable to be sued for mandamus.
If there was a property right to enforce in the first place, and you're making that assumption,
okay,
if we
right.
assume that there was, then we get to the mandamus claim.
Let's go right to Judge Gordon's property right analysis. What case law supports the view that there has to be a property right for a mandamus action?
Well, there needs to be a substantive
What
property.
Case law? What case law?
Well, I mean, there is no case law on the Medical Marijuana Act. I believe.
No, I'm just talking about any. Have you found any mandamus case that says that under Arizona law that says there has to be a substantive underlying claim?
Well, specifically the Grand Canyon Pipelines case cited by Judge Gordon was a case. It was a special action case to compel.
That was a case for a declaratory judgment to declare the rights of the bidders.
Well,
or excuse me, for damages. Because I thought one bidder was disgruntled and sued. Am I wrong on that?
I don't know the underlying pleadings in the case,
that's really important. Well, let's assume that's not a mandamus case. How is it applicable here?
Well, the reason it's applicable is the plaintiff needs to have a property right to be enforced to come into court and ask you to enforce it. Let me give you an example. I'm a public citizen, and I do not like what a certain elected official is doing, but what they're doing has no effect on me whatsoever. Can I file a lawsuit to force them to do something?
Is that called standing?
Well, we can call it standing, yeah.
Okay, let's go to the motion to dismiss you filed.
Yes.
Nowhere in there does it say property right. It talks about standing. You alleged that you argued lack of exhaustion of administrative remedies, and you also added lack of standing. But I saw nothing in there about no property right. And I don't know where the property right analysis came up. Honestly, where it came out,
yeah,
where it came from.
It was raised by Judge Gordon, I believe, in oral argument, and he did not, I believe, agree with the argument on standing. As we know, standing is very easy in Arizona, unlike you would find in federal court. Standing is very easy to make a claim for, but everybody can't go to the courthouse and sue for everything. And I think what Judge Gordon recognized in looking at Grand Canyon Pipelines was that the applicant here, in filing the application, what was the right that the applicant had? And the right was just not even a right, it was an interest in having the process completed. And counsel admits this in her reply brief. She says in her reply brief, I think it's on page 12, we are not claiming that we have an interest in the certificate. What we're claiming is that we have an interest in pursuing the certificate and an interest in the application.
Didn't they allege they have an interest in a non-arbitrary proceeding?
Yes, they did. They did, and I believe that one of their cases, the Supreme Court case, the Cuyahoga versus Buckeye case, if we look at that case, the Judge Scalia in the concurring opinion said we would find, according to him and Justice Scalia and Justice Thomas, we would find that even in the face of an arbitrary action, you don't have a springing of a property right. And I think what you're doing, if you look at it that way, you're placing the remedy ahead of the right. The question is there a right to begin with? And if there is a right, then remedies arise from that right, and those remedies may change depending on the severity of the state court action being charged. But in this case, the fact that you allege that what happened was arbitrary does not create a state right. Now, people will say, well, isn't there something we can do if they're being bribed or if they're doing something that is legally improper? As a private citizen, I think the answer is no. But are there actions?
It has to be the level of bribery?
Not bribery, but anything that is improper.
But
as a private citizen, we can vote them out of office. We can remove them from office. We can lobby.
Let me ask you, though.
Yes.
And I understand the concern stated somewhat differently than you have, that there have to be limits, or you simply open the door to the courts for everyone who may be completely disinterested in a process. And I understand that. Compassionate, though, it isn't a stranger off the street. They're one of apparently three, and I understand there's some confidentiality overlays that I don't want to run afoul of. Entities that either have or believe they have or have said they have invested hard money, kept money, time, to be considered for an award. And as a dissatisfied participant in that process, Compassionate has said, hey, we don't think the regs and the statutes that existed at the time were properly or fairly enforced. And that's one way to look at their claim. And so they're not off the street. It's a small number of quantifiable and easily identified individuals. And one of those is seeking to challenge that through a pretty extraordinary and difficult procedural mechanism, mandamus, among others. And your argument is that they haven't shown enough to get in the courtroom.
That's correct. They do. You are correct that they do have more interest than the disinterested person I mentioned. Absolutely, that's a given. But if you look at it, there are actually two things happening here. One thing, they're saying you didn't give it to us, and that's wrong. And in fact, I don't know if they've abandoned that now, but one of the claims in the complaint, where the prayer for relief was, give the certificate to us. They did not receive the certificate because they lost a random drawing, and there's no allegation that the random drawing was unfair, the drawing itself. So that piece of what they're claiming was, you lost the lottery. I'm sorry, that does not create a cause of action. The second piece, though, is I think the one that you're looking at, which is more significant, and that is, you found somebody else qualified. You put them in the drawing. We don't think you should have done that, and therefore, if you hadn't put them in the drawing, we would have won. What that necessitates is a challenge by one applicant for a license against the qualifications of another applicant. Now, we argued, I think, quite a bit in our briefs on why we do not have a system and cannot have a system where licensed applicants are running around challenging the qualifications of other applicants. But let's assume in this case that they can.
Okay.
Let's look at the facts alleged. The facts alleged were that Compassionate Care submitted the documentation necessary to get into the drawing. The facts alleged were that the other applicant, one other applicant, submitted the documentation necessary to get in the drawing.
Actually, there was two other applicants. There
actually were two other applicants, but I think at the end of the day, the allegations were the second of the other two applicants was not qualified.
And why?
For two reasons. Zoning, and the property owner would not allow them to operate a dispensary there.
Notified him that it was that wasn't there. It wasn't the third applicant. Who notified them that was no longer their application was no longer complete?
There's an allegation in the complaint that the Department of Health Services sent them a letter that said, this was early on in the process, that we have a problem with your application for two reasons, zoning and property owner will not let you. And one of the requirements was the property owner lets you do it there.
Specifically reference the letter from the May letter from Attorney Del Patton, Winslow City Attorney.
I don't recall whether it specifically did, but I expect that was probably one of the reasons that letter was sent to the other applicant. Yes. Now we submit again. The record doesn't say this, but we submit that there were two issues in that letter as alleged. If both of those issues were not cured, then that third applicant would not be in the drawing. We don't know whether both of them were cured because we don't have those facts, and frankly, I don't know how we get them. But
was the department exercising some discretion by kicking out the third applicant?
The discretion being, in our judgment, the third applicant is not qualified for 2 reasons, and those were the 2 reasons. Now, we don't know. It's theoretically possible that what happened subsequent to that letter was the department investigated both of the other 2 applicants and made a determination that the zoning issue was not an issue that would disqualify both of them. And for that reason, and again, we just speculate on that, but for some reason, the department let the other one who was in the drawing into the drawing, did not let the third one into the drawing. The third one had 2 problems, again, zoning and property. The one who got into the drawing had just 1 problem, zoning. Now, if we look at the law, there was a requirement that the property's location be in compliance with zoning. Now, there's even an allegation in the complaint that the other applicant's location had a conditional use permit. It was just issued to somebody else. Well, the department's discretion here was, we know that to be in compliance with zoning with an open operating dispensary, for example, if the zoning requires a paved parking lot with 3 handicap spaces, you're going to have to do that to be in compliance with zoning. Was the department going to require that at the drawing stage if the applicant had raw dirt? No, not at all. So compliance was a discretionary determination based on a number of things, including the status of the property on the date of the application. And how do we know that? Because if you look at the rules, it was a multi-step process, and the certificate got you into the game. That's all it did. So of the 500 applicants...
But the allegation here, again, we're assuming the truth of every one of these allegations. The allegations is that the city of Winslow specifically had a requirement that every applicant for a medical marijuana dispensary shall obtain a conditional use permit from the city of Winslow prior to submission to the department.
I agree with you that that is in there.
Conditional use permit that had to be for that particular dispensary, it was non-transferable.
Yes.
So even if there was another conditional use permit, it wasn't transferable. Each dispensary had to get their own.
I agree that that is an allegation.
Assuming those facts, how is it not at least arguably an abuse of discretion or acting arbitrarily to allow that bidder, that applicant, to move forward in the face of a zoning ordinance that is directly in conflict?
For a couple reasons. I won't parse the language of the complaint right here, but our reading of that was the city required to open a dispensary, you needed certain things, not to have the right to go through the process, number one. Number two, the planning director of the city issued a letter to the department, and we know this because it's alleged and attached to the complaint, that said, this individual is in compliance, this property is in compliance.
And if the record stopped right there, I think you'd have a lot stronger argument, counsel, than you do when the department decided to go to the next level.
Mm-hmm. And
start exercising discretion.
Well, and here, keep in mind, the only other allegations in the complaint that are on this are that the city attorney was of a different opinion. As we know, attorneys can give their clients advice and their clients can ignore it, not listen to it, or do whatever they do. From our perspective, the town planner was speaking on behalf of the town. He issued a letter. You'll notice that that was never withdrawn. There's no allegation that that was withdrawn, that anything happened subsequent to that.
I understand that, but then the allegation is the department took that to the next level and used that information to strike applicant C and allow applicant B to stay in the game.
Yes, so the department engaged in its discretion to determine who were the qualified applicants.
Your argument today is that discretion is completely unfettered, unreviewable by any court in this state.
That is the mandamus cases. Well, let's talk about the liquor license cases. That was the APR case. The mandamus is, you are not doing your job. I order you to do your job, whatever that may be. It's not, I order you to do your job and you shall issue or deny a license to a specific party. In this case, did the department do its job? It processed applications, made a decision, and issued certificates.
Let me ask you, though,
Yeah.
doesn't that dichotomy, and I understand what you're saying, but doesn't that direct what form of relief, how extensive relief is granted, as opposed to whether you have an entitlement to even seek relief?
I agree. Yeah. The mandamus, again, is assuming that you already have the right to seek that relief. But if we've stepped through and you have that right and now you go to mandamus, at the time the complaint was filed, everything was done. The certificate was issued. The drawing had been held. What they really asked for, and this was in the complaint, give it to us and take it away from the other guy. And if they've abandoned that, I won't argue my indispensable party argument, because we could have only one in this job.
On that point, I mean, did the proceedings permit Rule 19 to be fleshed out, if you will? I mean, did the court order that the unnamed party be brought into the action? Was there a court order saying you bring them into the action as a party, not to be served, not to be allegedly served, but because you know what I mean there, sending them a letter and emailing is not service. But did the court order them to be brought in as a party?
Yeah, there's a minute entry in the file. I don't have the docket number, but the court ordered us to give notice to that successful applicant of the pending litigation and invite them to participate. Did not order us to join them because we have no reason to join them. They are honest people who did their job and got their certificate. We have no reason to sue them, so we did not join them. He did grant the opposing party an opportunity to join them. And I see I'm out of time. Thank you.
Thank you. Thank you, Mr. Foss. Ms. Ward, rebuttal.
Your Honor, I do have the Grand Canyon Pipelines case, and there's significant differences in that and the lottery process that the DHS at its own discretion chose to implement. In the Grand Canyon case, it was all about a contractor, whether bidding on a contract gave them a property right.
What was the contractor seeking?
The contractor was seeking damages from, he was seeking two things. He was actually seeking either award of the contract because he was the lowest bidder, and if he wasn't going to get the contract, then he wanted damages. But in that case, there's no comparison here. There's distinguishable differences. There is no contract between the DHS. There's no bidding process. There's no review of awarding the contract to the lowest bidder and or qualified person. There's nothing even akin to it. When they grant the certificate is permanent. There's no way, there's no contract that's ever developed. There's no statement of work. There's no RFP, which is a request for proposal. There's no milestone set up where you have to complete certain milestones and you get paid along the way. At the analogy to Grand Canyon Pipelines, we feel the trial court erred when it used that as an analogy to find that compassionate care didn't have a substantive right or a due process right. My counsel here would have this court believe that, yes, they admitted they have discretion, but then they would say, but we can't review that discretion, no matter if it's abusive, capricious, or whatever. I mean, even though we have the letter from the city attorney dated May 25th, where he said that both of these applicants, neither of these applicants qualify to have a dispensary in the Winslow CHA. And they go so far as to say the only one that has met that requirement is compassionate care. Now, we have never said that we have an absolute fundamental property right to operate a dispensary. That's where I think the trial court got confused, because if that's the level of query, then no, we don't have a fundamental right to operate a medical marijuana dispensary. I don't think that's what we ever argued. What we did argue, and we do feel that compassionate care has a right to, is a fair and equitable implementation of the lottery process. That's all we've ever asked for, is that if you require us to meet local zoning requirements, then you should require number B and number C to meet local jurisdiction zoning. And when you've got this city attorney writing a letter saying that they don't, and then we've got a letter from the DHS that they mail to let's say number B, that says, in reliance on this letter, we're excluding you from the lottery. Because of this letter, we're excluding you. But they didn't do the same thing for TMR, the other number 3, even though it suffered the same deficiency.
Just for clarification, it's our understanding that the record on appeal is not sealed. So, if council want to take some action on that, because it's not currently sealed before us.
Well, it's public record now who holds the dispensary, and they're operating openly and publicly, and they're even on the list on the DHS website. You can get a list of all dispensaries, and they're there. So it's not pertinent. And even the confidentiality provisions were not absolute. The confidentiality provisions that the DHS would like to use to skirt responsibility specifically says that it only applies. It was to protect card holders and dispensary owners from federal prosecution. That was really the purpose of the confidentiality. And it says, except when necessary for authorized employees to perform their official duties. And so even the confidentiality provisions are not absolute, but that's not the issue that we're arguing here. We're just simply saying that compassionate care was wrongfully denied a right to seek judicial review. It was given no administrative opportunity, and the department even held the position that it didn't have to tell them, didn't have to give notice of any administrative remedy. And the court said, you're being a little schizophrenic in your argument here. You say they do, and then you say they don't. And so it was totally confused. Even the court was confused. And as far as standing goes, the court clearly found that compassionate care had standing. The court found, that they had suffered damages. They said that in his ruling. And as a matter of fact, the court termed it tons of money spent because that's what we were showing to the court, that compassionate care had been harmed by the arbitrary and capricious actions of the Department of Revenue in the carrying out of the lottery.
Thank you, Counsel. Counsel, as you can tell from our questions, you have given us much to think about. We appreciate your briefs. We appreciate your oral argument today. We will take the matter under advisement. We'll issue a decision in due course. I apologize to all. I should have acknowledged as we started, we do have a group of visitors today, some students. We're delighted to have you all here. You have as your docent, among others, our chief judge and her judicial assistant. We're delighted that you're all here. So, again, I apologize for not recognizing that as we started. And counsel, there is undoubtedly interest in your case, but I wanted to make sure you understood why we have such a full courtroom today. We're going to take a break, and we'll set up for our next hearing. Thank you.